Hey, this is Shen. Today I'll be discussing about the case, the State of South Australia and the Commissioner of Taxation. I'll go over with you some of the facts of the case, how did it trigger the constitutional issues, the effect on the current Australian tax system, the legal principles, and the effect on how the tax practitioner should advise on their clients on a similar matter. So without further ado, let's get started. Before I dig deep into the case, let me give you some context of the Australian taxation system. As we all know, the Australian taxation system is one of the most complicated tax systems in the world. In Australia's federal system, there has always been a lot of controversial issues in terms of how the taxing power is allocated between the Commonwealth Parliament and the state governments. The Australian Constitution gives the Commonwealth power to make laws in respect to taxation under Section 51(2) of the Constitution. This is known as the concurrent power of the Commonwealth. The Commonwealth must not use this power to discriminate between states or part of states. However, there are sections in the Constitution that limits the Commonwealth power under Section 51(2), including Section 55, Section 90, Section 99, and Section 114 of the Constitution. For the purpose of this presentation, I'll be focusing on the Section 114 of the Constitution, which prohibits the Commonwealth to tax on the property of any kind that belongs to the states. The South Australian case concerns with the constitutional issues in regards to the Commonwealth's lawmaking power on taxation under Section 51(2) of the Constitution. This case triggers the High Court to consider whether the Commonwealth's impose of tax on interest income and net capital gains of the state of South Australia and the South Australian Superfund Investment Trust, which I'll refer to as the taxpayer hereinafter, is of a tax on property as the meaning given under Section 114 of the Constitution. The South Australia Superannuation Fund Investment Trust was established under Superannuation Act 1988. It was to provide super benefits for the public workers and officers of the South Australia. The defendant, the Commissioner of Taxation, recognized the trust as the state of South Australia, and the fund was the property of which the taxpayer derived interest income from lending money and also net capital gains from the disposals of assets. They argued that they were not liable for these two incomes, relying on Section 114 of the Constitution. It was held by the court that the taxpayer was not exempt from and was liable for the tax liabilities on the interest income from lending money. The court unanimously held that the tax on interest income is not a tax on property. Dawson Justice stated that the interest income falls within the assessable income and taxable income concept under Section 17, Section 6, Subsection 1, and Section 25, Subsection 1 of the Income Tax Assessment Act 1936. The interest is considered as income that derived from money lending activities and transactions by the taxpayer, which involve the property, rather than derived from the holding of ownership to the property. However, Brennan and McCall justices they dissented that the ordinary concept of income gives the interest income the meaning of a property. They contended that the impose of tax on the interest income that the property receives is of a tax on the ownership or holding of the property itself. On the other hand, the High Court held that the Commonwealth's tax on the net capital gains of the state was a tax on property that belongs to the state under Section 114 of the Constitution, and the taxpayer was therefore not liable for the tax liabilities on the capital gains. The High Court contended that the state's right and ownership to the property was fundamental for it to derive net capital gains from selling the assets and property. Besides, the fact that the property must be held by the taxpayer to enable the calculation of capital gains has further indicated that the tax on which will be a tax on the taxpayer's ownership or holding to the assets. So now, what are the legal principles that are developed in this case? First of all, Section 51(2) empower the Commonwealth to make laws in respect of taxation, and the Commonwealth must not make laws that may discriminate between states or part of states, a result of which would make the laws invalid, as it is beyond the lawmaking power that the Commonwealth is entitled under Section 51(2). However, Section 114 of the Constitution limits the Commonwealth power under Section 51(2), that the Commonwealth shall not impose tax on the property of any kind that belongs to states, nor the states are allowed to impose tax on the Commonwealth's property. In this case, it was held that the taxpayer was not liable for the tax on net capital gains. The High Court held that the net capital gains of the taxpayer shall not be taxed by the Commissioner, as the imposition of Income Tax Assessment Acts can be characterized as a tax on property belongs to the state as per Section 114 of the Constitution. When deciding whether Section 114 will apply, the relationship between the taxpayer and the property must be considered. Indicators of the state's rights to sell the assets are the state ownership to the property and also the length of time that the state has held the property for. These indicators are the essential elements for the net capital gains to be calculated. In contrast, the interest earned from money lending activities by the states did not have these characteristics. The interest income fall within the concept of assessable income and taxable income under Section 17, Section 6, Subsection 1, and Section 55, Subsection 1 of the 36 Acts. The interest income was derived from the activities and transactions that involve the property, but not by holding the property itself. The length of time has also no effect here because the derivation of income tells us that the interest is to be recognized when it is due, usually during the end of the income year, and to allow the taxable income to be calculated after taking the allowable deduction into consideration. So how do these principles relate to the current Australia tax landscape? In terms of the tax treatment on the interest income earned by the state lending money, no legislative actions have been taken by the Commonwealth, as it was decided in the case that the tax on interest income was not a tax on property as defined in Section 114 of the Constitution. However, as a result of the decision that the Commonwealth's tax on net capital gains of the state is of a tax on property as defined under Section 114 of the Constitution, and as a resolution of these particular constitutional issues, an amendment has been made in the 36 Acts. Section 271A was inserted into the Act to guarantee the protection of funds that are constitutionally exempt from tax, so-called the Constitutionally Protected Fund, CPF, in a section. The section for CPF has been rewritten into the 97 Act. In the Regulation 2021 subsection 995-1, it defines a CPF as a fund whose assets and property belong to a state of Commonwealth. The Commonwealth's tax on this superfund will be invalid as it is considered as a federal tax on the state superfund that is inconsistent with the Constitution. This section applies to the assessment made in the respect of the 1993-94 income year and the following income years. However, if a CPF assumed that it was exempt from the tax on all of the income of the year and therefore not paying the income tax, the section will apply to the assessment made in respect of the 1988-89 and the following income years. So how does this case impact the tax practitioner on how they should advise their clients? Assuming that the client is a state-owned superfund, in terms of the similar cases regarding the tax treatment on interest income, the client might not be successfully exempt from the tax liabilities. As per decision of the case, it was held that the tax on interest income is not a tax on property, and the interest income falls within the meaning of assessable and taxable income under Section 17, Section 6, Subsection 1, and Section 25, Subsection 1 of the 36 Acts. The interest income derived from the activities and transaction by the superfund might involve the property, but it is not by holding the property itself. However, the tax practitioners will need to advise their clients on any possible argument that could be raised to exempt from the tax liabilities on interest income. If the client is able to prove that the derivation of interest income is directly related to the ownership or holding of to the property, it might be able to exempt from the tax liabilities on the interest income. However, the client needs to really know that based on the decision of the case, it is the original jurisdiction in the High Court of Australia. It has the most powerful decision among any other courts. Therefore, the client should be advised that it is unlikely to be successful in arguing the client is exempt from the tax liabilities on interest income based on the decision of the case and the principles that I just discussed earlier. In terms of the tax treatment on the capital gains, if there is no such legislative amendment made in the Act by inserting the section for CPF, the tax practitioner will need to determine whether the client is of a state of the Commonwealth and whether the tax on capital gains is of a tax on property, so to work out whether Section 114 will apply so that the client will be exempt from the tax liabilities. Given that the South Australia case had its original jurisdiction in a High Court, and by following the doctrine of precedent, the decision that the tax on capital is of a tax on property will result in the client be successfully exempt from the Commonwealth's tax on the capital gains. However, as a result of the legislative amendment made as a resolution of the decision on the tax treatment on capital gains in a South Australia case, if a similar case is to happen today, the fund would be a CPF as defined under the Section 995-1 of the Regulations 2021, and the fund's income will be exempt from the tax liabilities under Section 50-25 of the 97 Acts in the Table Item 3. To conclude, the South Australia case illustrates the constitutional issues in regards to the Commonwealth's power to tax on the property that belongs to the states under Section 114 of the Constitution. Over the years, there has been a lot of cases that trigger the challenges against the Commonwealth's power to make laws on taxation, while the South Australia case is just one of them. The law-making power on taxation under Section 51(2) is a fundamental power of the Commonwealth Government. The sections that add as the limitations on that power needs interpretation of the common law to develop a better understanding of what the sections are intended to achieve. The decisions in every cases are significant. It affects how the later cases in a similar situation should be decided. Before the South Australia case, there wasn't any section that provided protection in terms of the taxation to a state-owned superfund. It was the decision of the case that results in the section for CPF to be in place, so not only to provide certainty for the superfund, but also aids the tax practitioner to provide certainty for their clients. Cases are happening every day. We should keep an eye on them as there might be more decisions and changes that might affect how the later cases in the future should be decided. Well, it comes to an end of my presentation of today. I hope my presentation helped you to have a better understanding of the case and also the legal principles and the effects on the current Australian taxation system and also how it affects the tax practitioners should advise their clients. Thank you for listening.